fair. They do have to make sure that they win the day. I can see people getting their buttons pushed as a judge, but I think you have to always remember you gotta stay calm.
So here's my take. If he had committed jury tampering, he was going to get in trouble for that. Now you're raising that in a different case. As I say to you and the kids all the time, what's one of my favorite things to say?
What's your goal?
What is your goal?
Yeah, what's your goal?
What is your goal?
Yeah.
You're in another case. You're fighting in another case.
Yeah.
He thinks, stepping in his shoes, he thinks this judge is someone who would tamper with a juror. What is your goal of making that accusation in another case? Is your goal to lose that case? Is your goal to potentially get in trouble with the bar? Like, what is your goal? That investigation is being done outside of this one.
It seemed like he was trying to bring it back to this case somehow, kind of needle the judge a little bit. But
That's how it felt to me.
yeah.
So that judge was later, turned out to be baseless, right? So it seemed. So if I'm being investigated for something very serious that will cost me my reputation, my career, my bench, everything, and I know it's baseless, and you accuse me of it, how am I going to react? Not well. Let's say he did it. He's still not going to react well. You have no upside. What is your goal?
About his reaction. His reaction used in this other case while pushing the judge.
I would think that if you're under an investigation like that, you can look at the tapes for all different types of cases, and that the reaction doesn't bode well for you, but obviously it didn't have an effect.
So he made statements. He started to say what he didn't do.
Yes.
So he made substantive statements like, all I did in that case was A, B, and C. Okay, you just made a statement. You know, that old, whatever you say, cannon will be used against you. He could have shut that whole thing out of ever making a statement that could have been twisted or turned or used against him. So, and I do think that generally it's very hard. I cannot imagine how hard it is to remain calm when you're falsely accused of jury tampering as a judge. But any lawyer advising him would have said, if that ever comes up, remain calm. I'm not being critical of him. I can't imagine it, but,
You know
but
what?
it's the right move.
It's something I say. Less is more.
You do say less.
I say that a lot.
When I start talking.
When you start No, but when you're negotiating or talking to the other side, you have to listen, and less is always more. So it's like as much as you want to go off or as much as you want to say stuff, it's like less is always more. All he did was potentially give that attorney and whoever was investigating him more to look at. Just don't say anything.
Next, we're in Denver, Colorado, for the deposition of attorney Robert Abrams. Abrams' firm was added as a defendant alongside their client in a lawsuit between two former business partners and are being sued for fraud, conspiracy, and aiding and abetting a criminal by the plaintiff.
Good morning, Mr. Abrams. Do you understand?
Sorry, Annoyed.
To give the deposition today?
No.
Literally, I've seen thousands of people give an oath in a deposition, but from the way he raised his hand to the way he started, this is not going to end well. Now, I know we're watching this, so I know it, but as someone who's done it, I could have already told you this is going to be a memorable one.
To say tensions are high in the room would be an understatement. Asking the questions off camera is the plaintiff's lawyer, Tom Werge. And on the other side of the table is Abrams' lawyer, Neil Sullenberg.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You sitting here today under oath, you have no idea whether you've been deposed before?
I've answered that question, object to form, move on.
That's so funny. That's a litigation attorney acting almost like he's his own lawyer.
Got his role.
Yeah.
Well, his lawyer is supposed to say objective form. He's supposed to let his lawyer do that, but he's a lawyer, so he couldn't help himself.
Playing objection in the deposition and, in effect, asked the attorney to clarify the question.
Have you been deposed?
Objective form.
Objective form, move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master. Good morning. Yes, we are in the middle of a deposition this morning.
But when the special master isn't available, plaintiff's attorney Tom Werge asks the same question again.
Mr. Abrams, have you had your deposition taken before?
And gets the same answer.
Objective form.
Asked and answered, move on.
To answer the question.
The question was answered. Excuse me, have her read it back.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing you.
We're gonna move for sanctions
I'm
against
asking
you.
you to
If you're not
answer
going
the
to
question.
allow
He just
for-
answered the question.
I just want to point out one thing. This is literally over him going, I don't remember if I took it up. What are they fighting? They haven't even gotten anything. Nothing's even happened. And they're fighting about this. This is why he's going
His own objections, which a witness is not allowed to do during a deposition.
I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you
Objective form.
for continuing to obstruct and not answer any of my questions. You cannot object.
I just did.
You cannot.
I just did. I'm a lawyer.
warehouse
I'm
grounds.
a licensed, unblemished member of the bar. Unblemished. If you
There's
have
the
any
warehouse
more
dog.
time, I can walk out.
We're gonna move for 30D3
We're
sections.
going to move for harassment sanctions against you right now.
Things only get worse when the arguments take up personal
I should
turns.
try to stay out
We're
of
going
sight.
to be here for
Now
a
to
long
find those
time today
records.
if you do not answer my questions. I can't even get through my initial questions because you are being so obstructionist.
That's
today.
because you're a weak lawyer. You have a ask us front questions.
Okay.
This actually goes on in our courtrooms? Jesus Christ.
Object to form.
None of your business.
My God.
Privilege.
Where's decorum?
Object to form. Object to privilege.
Go be wild and crazy in your own life, but when you get in the courtroom, have some decorum, you know?
This whole thing is childish. This is not normal. This is ridiculous.
Do-do-do-do-do.
Everyone needs to chill
Okay.
and understand what their goal is of this deposition. But once you go personal like that, you risk losing your credibility when the rest of this stuff comes up.
Also, it looks a little weird. Like, why are you taking any sort of pills like in the middle of a deposition? Maybe if it's Tylenol and you're like, I want to take a break or something like that. But to just start taking pills like in the middle of a deposition is a little bit awkward.
You can take a, he's a lawyer. He knows full well you can take a break whenever you want.
Yeah.
There's a lot of ways to object to it. Say objection, objection, asked to objection, assumes facts not in evidence. Objection, hearsay. Objection, lacks best evidence. So there's so many reasons to object to evidence that are all very legalese, right? What's happened is some states have said depositions are taking too long, we're fighting over too many things. There's no judge in the room in a deposition. So just say object to form, and when we get to trial, we can argue over what was right or wrong about the question. So it's a way to simplify depositions. And it does do that, but it doesn't always do that.
Object to form.
If you want to raise your weight problem, Mr. Ward, with the jury and with the special magistrate, just what's going to sit here in that condition?
I am going to end this deposition now. Mr. Abrams, we're going to continue it while we seek intervention of the special master. It's clear that you are not here to answer any questions today. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition.
Please do.
Here's the worst part. Until he went to the weight stuff, he had a really good argument from what we saw that
Maybe
he
this will
answered
help
the one
Agapios
stupid,
identify the
meaningless
dagger's
question to
leader.
the best of his ability, move on. The plaintiff's lawyer wouldn't let that go. It had been answered. But now, don't you think he hurt his situation?
Yeah, he was just being attacky.
Records
But
of
I think he
shipment.
felt tapped.
What
so he
docked
was
where
just
and
like,
when?
I'm going to let you
This
have
might
it.
help
But
Agapios.
it's silly sometimes the questions that certain attorneys do ask. I mean, we've been part of depositions where the guy's 30 years old and they go back to when he was 5. Like, why are you asking these questions?
I agree. And asking over and over and over, have you given a deposition? I think so. How many? I don't know. Have you given a deposition? I've answered it. Have you given a deposition? Like, I can't give you more than I think so, I don't remember. So that was all on the plaintiff's lawyer, totally unnecessary. I definitely think he was doing it. If he's an experienced lawyer, he was doing it solely to get under his skin.
Yeah.
And then it worked, which is, as a witness, don't let the jerk lawyer win.
No, 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 no.
Transcripts from the deposition.
Slow-mo.
The special master issued
Bye.
an order for sanctions against Abram. His behavior during the deposition, along with other misconduct in the case, would ultimately earn Abrams a 9-month license suspension.
9 months. There's got to be more. They did
There
say
has
there's
to be
more.
more.
9-month suspensions are not given out lightly. That's a huge, huge deal.
Hey, banana.
Especially for it to be a 9-month suspension just for like what happened in
What
the
we
deposition.
saw, come on.
That was not. Yeah.
Fine. They said there's
Banana,
more.
can you
There's
go
gotta
get me a
be more.
Gatorade?
There's
And,
always more.
but it's just so frustrating. If you really
I
thought
wish
they
my
had
cat
enough,
could get me a
just
Gatorade.
Trust the evidence. Trust me
Yeah.
as your lawyer.
Answer the questions.
And maybe he did it, but if he didn't, his lawyer,
Oh.
the guy who was being
Don't pay attention for the next 5 seconds. No, I didn't do anything.
You would advise someone to do, or we're gonna just end this for the
Hi,
day
Nana.
because you are burying your own grave.
Hey,
You
baby.
trust me or not? You hired me. Do you trust me? Because he would never let that guy and star personality, he would never let his own client act that way. But when you're in it, it's a lot harder, I'm sure.
Our next story takes us to Clark County District Court in
Oh,
Los
I know
Angeles
this
for a
one.
kidnapping trial.
Defendant is here. He's in custody.
There's just one problem. The defendant's lawyer is nowhere to be found.
Let me check and see if he's going to join.
Damn, baby girl. You ready?
After a 90-minute delay, defense lawyer Joseph Caramango finally arrives in the courtroom.
Have you seen this?
I think I have seen this, but it's been a long, long time.
I know this.
If a lawyer is 90 minutes late, do they actually just sit there and wait, or does it come to a point where like, okay, we're done for the day?
Every judge is different. Every county is different. So it totally depends. Some judges, if they have a busy calendar, they just put it off to the side. But this is a trial, so nothing else is going on. So I think most judges would leave the bench, let the other lawyer do some other work. But that may have happened. In fact, my guess is that did happen in spite of the way it's been edited here, so that everyone can do things but stay close. Because they have a jury ready to go. They have a defendant ready to be tried. Everyone's ready to go. Where is the lawyer? Like, that's highly unusual.
I do feel like usually the judge or the judge's clerk will reach out to the attorney's office to try to
sure
find
that was
them.
happening.
So like they're trying to find them and figure out what's happening.
And you can be late. I mean, you can't be late, but it does happen. If you're going to be late to court ever, let alone for a trial, most lawyers would feel compelled to call up,
Yeah.
email, beg, explain. So to not just show up for 90 minutes, if that's what happened. This is a crazy start. It's about to get crazy.
Judge, I was heading
Hi, baby girl.
east on Sahara Drive.
No, no, no.
I was rear-ended, and my car was undrivable. The person who hit me took off, and
Hit and run.
Records of the trades envious made in the last 6 months. Maybe the identity of the
I'm gonna
dagger's
tell you,
leader
to
is
be
in here.
honest with you, you don't look right this morning. That's why I'm concerned.
Judge, my neck and my back is killing me, but I'm ready to go forward.
You don't think you need medical attention?
I think I do, Your Honor.
I found the
may have
record.
suffered a concussion, Your Honor,
Because you hit your head?
because of the whiplash, Your Honor. I've had multiple concussions before.
You've had multiple concussions.
Yes, Your Honor. But I feel like we can go forward.
You know what? Can I just see everybody back in chambers?
Behind closed doors, Caramango meets with the judge and is assessed by a courthouse nurse.
And the record reflects that Mr. Caramango is back in the courtroom. He has been checked out by the nurse.
I've seen this, but you do see they got the bailiffs, the officers hanging out in the back. Court security is in the back. That's not a good sign.
Now, the nurse said you told her you got hit from behind and then you hit a car in front of you. Okay, you left that part out with us.
Yeah, I did, Your Honor.
So you also hit a car? So it was a double hit and run.
I guess.
The judge is becoming increasingly suspicious of Caramango's story, and the prosecuting attorney isn't doing him any favors.
My observations were observing him that there was clearly something wrong with him. I noticed he was slurring his speech. I noticed he seemed unsteady on his feet. And when actually Mr. Caramango came back into the courtroom, he seemed very unsteady on his feet as he walked by and actually ran into our counsel table.
Things only get worse for the defense lawyer when the judge orders him to take a blood alcohol test.
I think you have a concussion. I think you're dazed and confused and can't tell a straight story because you're too intoxicated.
I admit that I did have drinks last night, and I lost my grandmother about 2 weeks ago. I've been under a lot of pressure, Your Honor. I'm
Okay.
well aware of that.
So if you came to court intoxicated, you have a problem. Do you understand me?
Your Honor, I can represent as an officer of the court. I am not intoxicated.
Okay. So just go ahead and blow. Let's get it over with.
Can you imagine?
Being the client.
How do you think about that? Oh my
Oh my god.
Watching the client. You're like, no, I'm just thinking about being the attorney.
Like right now, his heart has to be beating a million miles an hour. I don't even know what the law is if a judge tells you to blow, because like out on the street, it's a different world.
Yeah.
This is crazy right now.
Imagine they were there for a DUI and his attorney got a DUI.
But he's on trial for kidnapping.
Oh, shit.
He's facing years, and his lawyer shows up 90 minutes late drunk. Allegedly. We're about to find out.
That was close.
Slave market.
You want to show me?
Need to put this place out of business.
I'm stone sober.
Mr. Ken Mingle finds you, I would just be quiet at this. Okay, for the record, your blood alcohol is a .075.
Even though his blood alcohol content is slightly below Nevada's .08 legal limit for driving, the judge has had enough.
I have no desire to ruin your reputation or anything.
This is what happens when people talk about legal issues. If you're .075 after you've been in court for probably an hour and a half, you showed up in court too drunk to drive. And it doesn't matter if you're too drunk to drive. Way before too drunk to drive is too drunk to show up in court and represent a kidnapping defendant.
I'll give you an opportunity to get it together. But at this point, I cannot absolutely allow an attorney to proceed.
The judge declares a mistrial. Joseph Caramango's law license is put on disability inactive status. He's prohibited from practicing law in the state of Nevada and has not petitioned the state Supreme Court for reinstatement.
Well, that makes sense.
I mean,
He has a problem.
he's probably got a problem.
You know, being a lawyer is not easy. I always tell people, like, don't go to law school unless you really want to be a lawyer, because there's a lot of professions that have a lot of stress. So I think there's a lot of lawyers who have problems like that.
Alcoholism and drug issues are very high amongst the bar. People wouldn't think.
I never thought that, but then once we were lawyers for a bit, I was like, wow, there's a lot of lawyers who turn to alcohol.
If that guy that was being represented by the lawyer that was drunk, and that affects his case negatively, is he able to like sue the legal the law firm? Like, I know it was a mistrial. I feel like if I had my lawyer showed up drunk and that affected my case, I'd be like, we gotta do a redo. This is not fair for me.
So it depends on whether it's criminal or civil. That was a criminal case. It's called inadequate representation of counsel. Yes, if you can prove that your drunk lawyer fell below the standard of care for lawyers, you can get a new case. The fact that he was drunk helps you. However, there are people who have been sentenced to death and their counsel was asleep at the table for a lot of their trial, and we still let them be put to death. So it is sometimes not as simple as it may sound. Because I would rather a drunk lawyer than a sleeping lawyer. I don't want either, but if I had to pick.
What if he was already in jail, waiting for his trial, in jail, in his mistrial, because of this negligence from his lawyer? He has to go back to jail for an extended period of time.
That's a great question. If he's found not guilty, he could sue his lawyer for something called false imprisonment, which is a civil action for money, saying I spent an extra 6 months in prison or whatever it was because you're drunk delay and you owe me money for that, and if he can prove it, he wins. All right, if you liked what my brilliant wife Alexa Sapphire Breyer had to say, or maybe even didn't hate what I had to say, and you want to hear more, don't forget, like, subscribe, follow. Now hold on for a minute. See that? YouTube's like, click that show. It's amazing. Do it. Let us know what you like. We'd love to hear it. Thank you for watching the Husband and Wife Law Team. Actual, real lawyers who fight, commenting on what happens in court. I'm Mark Breyer, the actual trial lawyer. I'm actually in that well fighting for my clients, judges, juries, checking out law and crime sidebars, top 7 most heated moments between judges and lawyers. Let's watch it together and see what we see.
I gotta tell you, I don't remember in recent history maybe any more heated moment between a judge and an attorney than in the Parkland school shooter trial out of Florida. After he pled guilty, all the jury had to decide was what should be his punishment, life in prison or the death penalty. And I want to be clear here, this was an exhausting trial. And there was a point when defense counsel objected to victim impact statements that were directed not necessarily towards their client, but in their view, more towards them and their own families. When they tried to bring this issue up to Judge Elizabeth Schur, let's just say it didn't go very well.
These people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking. Miss McNeil, be quiet. When these people have sat in this courtroom
Let's hope no one
and
notices
watched
me here.
this behavior from that table, and they want to say that they're not happy about it, What is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper.
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony.
Okay.
Also.
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice.
You need to sit down right now. You're out.
Jeez.
In fact, you're excused. You need to go sit in the back with your chief public defender.
I have never seen that. I've seen judges get really mad. Admittedly, this is a different kind of trial, and judges in most jurisdictions are elected. So in addition to everything else, they have re-election to worry about. And I don't know what this judge was dealing with, but she deals with it in this whole trial. It builds up, it builds up. He talks about the judge's kids. So I've never seen you're excused, but I have seen threats of contempt and of civil contempt. So the you're excused thing, he's representing the public defender. So generally, an angry judge might actually put him in contempt or threaten contempt. So interesting to have her go like a teacher, go to detention.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back.
Is she really paying attention to what they're saying? I don't think so. She must have had a... Jesus.
I should watch my step around here.
That I have never. If you're gonna get up here and you're...
Oh my God, Judge, we get the point. Move on. Swift and speedy trial. That's the right. I'm gonna be such a good fucking lawyer.
Venom that the court is expressing is the same venom that the defense counsel had to sit through this entire morning when their children were being
Whoa! I actually have an issue with that. But here comes up
Roar.
Right? This is probably the boss over at the public defender's office trying to calmly give the argument that that's what we heard and he was just making the point. And you may disagree, but shutting it down, going back to the courtroom, it's a tough situation. I'm not going to pile onto the
Yeah, it's fire. Fire burns.
Bringing up the court's kids, really
Excuse me.
For all the other things he did wrong in that trial, his point was his kids got brought up. I did not see the victim impact statement or statements that he's talking about, and I would say this. I agree with the judge. You never bring up the judge's kids. Never. First of all, the judge is not the judge. The judge is the court. The judge stands for more than her or him. It stands for the integrity of the legal system. That's what the judge is in that moment. You owe respect to that judge and that court, no matter how attacked you feel.
There was another heated moment that came straight to my mind when I was coming up with this topic. The Kyle Rittenhouse trial back in 2021. Now, at one point, Kyle Rittenhouse took the stand to explain his actions. Of course, he was the subject of cross-examination by the prosecution. Here, prosecutor Mark Binger. And a couple of issues came up. One was Binger questioning Rittenhouse about his decision to remain silent after his arrest. Binger also wanted to point out that there was other evidence, prior statements of Rittenhouse, showing that he wished he had his AR-15 to defend against looters who were ransacking. And this was a problematic line of question. Judge Bruce Schrader took issue with prosecutor Mark Binger's line of questioning. While Binger was going to try to defend himself in this clip, he said the court left the door open to these inquiries. Judge Schrader admonished him quite expressly.
Well, Your Honor, this was the subject of a motion. I'm well aware of that.
Oh, I forgot.
The court left the door. My understanding of
you should have done an end. Why would you think that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to. Yes.
We filed another acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. Yeah, that's absolutely untrue.
It
And
is-
there are your arguments of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this.
So what's going on? You will hear this all the time if you watch trials, and if you ever go to a trial all the time, once the jury leaves the room, open the door. Did they open the door? Some whole trials are based on waiting for the opportunity of one side or the other to open the door. In this case, before the trial started, they filed a motion and said, Judge, we want to question the defendant about this. And the judge said, no for now, and I will consider it at a later time. And it appears, at least in the judge's mind, that they decided that later time had happened, the door had been opened. That's not how it works. If a motion has been filed and you think the door is open, you have to come to the court, many times the sidebar. Can we approach, Your Honor? Your Honor, we think in this examination, they opened the door. They asked a question that allows us to go into this area. But generally speaking, you don't get to just decide on your own the door has been opened and go for it. So you make these rulings before trial starts. That's what the judge has to do. The judge hasn't heard the testimony, hasn't heard opening, hasn't seen most of the witnesses. The judge is so limited in what they know before trial that it is not at all uncommon for a judge to say, I'll give you my answer now, but it's subject to reconsideration. You don't get to just assume the judge would now have changed their mind. You have to approach and ask the judge, depending on what the judge wrote and said pre-trial.
It was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitude. His
All right.
attitude is he wants to shoot people. Now,
What?
I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
That's a pretty big deal. The judge had just said my pretrial rulings are still the same, and then you go into it, it's a bigger problem. The judge has just said nothing's changed my mind yet. You can't just assume they did. And let me tell you how problematic this is for the judges. The judges have a super tight calendar. They don't have a lot of time. They promise the jury when the trial is going to end. And on top of that, they have another trial and another trial back to back to back on schedule. So if you create a mistrial by not listening to the judge has to restart the trial all over. It's a massive issue for the courts. They want you to play within the rules.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
That's exactly the bottom line. If you think the judge's ruling has now changed because of something that got brought out elsewhere, you ask the judge. It can be at a sidebar so the jury can't hear it. Judge, can we approach? It can be at the next break. But you don't get to just go into something the judge has said no to. That is a potential mistrial where you have to start all over. And you could get fined, sanctions. Sometimes that you'll be referred to the state bar if you ever do something intentional. It's a very big deal, and that's why the judge is so upset.
Let's go now to Delaware County, Ohio. Back in August of 2022, a man named Matthew Moore was on trial for the murder of his wife, Emily Noble. Body was discovered 4 months after she was reported missing in the woods. She was hanging from a tree by a U.S. cord. Prosecutors allege that Moore staged the scene to look like a suicide. Defense counsel argued that it was possible that Noble had in fact killed herself. And as that back and forth was happening on both sides on the testimony and the evidence, this trial was notable for one particular outburst, one particular moment from the prosecutor. See, Mark Sleeper and Melissa Schiffel were acting as prosecutors for the state. And on the 7th day of trial, the judge, Stephen Wolliver, wanted to move forward with proceedings, despite the fact that Schiffel wasn't there in the courtroom. Now, according to Sleeper, the court was informed 2 weeks earlier that Schiffel wouldn't be in attendance due to a scheduling issue. Well, Mr. Sleeper let the judge know that he wasn't going to just let this happen.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
I'm not not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I want to assume, for the purpose of what I'm about to say, that the elected county prosecutor did give the judge notice, that the judge said it was okay, and now the judge, in spite of that, wants to go forward with the trial. You can't leave the court. You cannot just leave that site unattended. Now, I understand you're forcing the judge's hand. The judges are wrong all the time. They're like referees. They're right a lot, but we remember when they're wrong all the time. They're human. They have their own biases and prejudices. They don't put on a robe and become unstoppable forces and never make mistakes. He did not have permission to leave. Now, his argument is going to be, actually, I did, because you, judge, gave us permission. But I do think he's risking getting in trouble with the state bar to just walk out like that. And he's also risking what the judge would do. Having said that, this does force the judge's hand. Is the judge can actually move forward with trial with nobody there? If he may have said on the record, that's okay, you don't have to move forward. But this lawyer better be right, and even then, he better hope things work out after he leaves that courtroom.
How could I talk about this topic
He was
without
just
bringing
another
up
man
Ralph
doing
Brooks
right
Jr.?
by his family.
The man who went
Too bad
to
he mixed
trial
with
out
the
in
wrong
Waukesha,
people.
Wisconsin. He was charged with 76 criminal counts for driving a red SUV into a group of holiday parade goers back in November of 2021, killing 6 people, injuring dozens of others. And at one point, he decided that he's going to represent himself. It was bizarre, from the arguments he was making to his outbursts that got him kicked out of the courtroom.
This court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. He took his shirt off as well.
That's a tough situation. You have the right to represent yourself. It's an old statement. Someone who represents themselves as a fool for a client. You cannot effectively represent yourself, even if you're the best lawyer. There's so many disadvantages to representing yourself, advocating yourself. You're too biased to see everything, and there's no one there to counsel you on the bigger picture. But beyond that, saying I didn't do it is not as powerful as saying this man did not do it. Or more importantly, saying they can't prove I did it is not as powerful as someone else saying they can't prove he did it. There are so many downsides to self-representation. Being crazy makes it hard.
They weren't ready for it. They scared of it. That's what it is. Oh man.
Mr. Brooks.
No man, stop.
When you aren't
Stop it. You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public
Remember
servant.
what you said.
Your
They were
job
setting an
is to be
example
the
for your
referee.
children.
I'm a grown man with grown kids. So
Agapios
ain't
needs to
nobody
know
gonna
about
talk
this.
to me like that.
I still
Nobody.
need to meet all of Agapios' contacts.
I don't have a problem with doing what you asked me to do, not tell me.
First of all, a judge can tell you what to do because it's the judge's courtroom. The judge actually, as much as it may offend you, doesn't even have to be respectful. The judge should show respect. The judge represents the court system in something bigger than themselves. But you don't get the right to just demand how you're going to be spoken to. And this whole you're a public servant thing, we've gone a little too far in a judge's courtroom to call them you're just a public servant. So you show me respect, this probably won't end well. You can see this judge. She's trying to make sure she stays calm, cool, and collected, which I have not seen this. Maybe she doesn't do. This will be good.
Just like when I asked you about subject matter jurisdiction that you had yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it. I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing
This
about
must be
this
the
is a
farm
joke.
Agapios mentioned.
That's what y'all
Now
don't
to find the
understand.
farmer and see what he knows about the dagger.
The defendant and the court with.
So that had to be said. The defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I got one ear that work, and I heard that.
This
Come on,
is
man.
to benefit you so that
No, it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has a
clear about
prior
that.
record. Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had
alleged
to elevate her
record of
voice
Abel
just for that.
Lescott. Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value.
Do you know how many people have gone to jail based upon the rulings a judge made, not the jury? What the jury hears, how it comes into evidence. The judge has so much power. Now, there are times you've got to push back on the judge. There are times you feel the judge is not being fair. There's times where you have to say to, in effect, this powerful referee, I'm going to make my point, so either you get it right or you get reversed. Everything he's doing is just getting the judge angry to hurt himself even more. On the other hand, I think maybe he's struggling with some other issues beyond just this.
Let's talk right now about Young Thug's RICO trial. We have to talk about the drama happening between the attorneys and Judge Glanville overseeing the case. You see, he runs a very tight ship in his courtroom, and the attorneys will know that. Because if you don't follow court rules of professionalism and decorum, oh boy, he's going to let you know. Like, for example, one of the defense attorneys in this case was held in contempt of court and was ordered to pay a fine and buy his colleague's lunch.
I want to look something up. I want to see if the Young Thug trial was in federal court. Oh, county court. Because a lot of times when you see judges who run a super tight ship and get really particular about their rules, it's federal court. Federal court judges are appointed for life. They have way more support. They have fewer cases, and they have power. You will file this on this color paper with this font. They often are way more particular and much more demanding than you will see generally in state courts around the country. So I was just curious if the judge was a state court judge.
Follow-ups on other business that we held earlier. Mr. Menendez, good morning, sir. You were supposed to buy lunch for your colleagues. Have you done that as of yet? You were supposed to have done that by March the 17th. Did you go to, did I told you Jason's Deli? Did you satisfy that prong of your contempt yet?
I don't believe I was.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. I just want you to pick a date.
Whatever dates you can report about Mason. If that works for me, Judge, and also I never saw the contempt order. I missed it.
Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt.
How do you not know if you're held in contempt? I'd like to rewind. Being held in contempt should be a big thing. Was the judge holding him in contempt, or was the judge going, I'm going to hold you in contempt unless you go buy them some lunch? And so they heard that very differently, and it's a big deal. To have been held in contempt is not a small thing for a lawyer. So it's a little bit odd how that either miscommunication or whatever was playing out there, I wasn't in contempt, yes you were, and I was going to send you for 20 days. That's a big deal. That raises some real issues about how the judge found him in contempt, if he actually found him in contempt, threatened to find him in contempt. You know, contempt is something that's used in movies and TV shows a lot, and in courtrooms not a lot. So it's an interesting moment, almost very odd to me. See a lawyer go, I wasn't held in contempt, judge. And then he was kind of smiling and lighthearted, so the whole interaction means there's got to be more to that story.
To the next matter, Mr. Johnson, how are we doing on that paper? I mean, the importance of professionalism.
My God.
Yours is due by
If I follow the road east, I should be able to follow the husband's
28th of
tracks.
April. I'm just checking, I'm just clocking. So we on track? Well, your better half said she's not writing it for you either, because that wasn't offered to you. You already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table.
We had a case in my jurisdiction where a judge ordered two lawyers to go to lunch together because they were arguing about everything. He even picked the place. This has got to be, 25 or more years ago. I understood it, right? It didn't feel like the judge did it a lot. I think the judge was like, you two need to grow up. You're going to go sit down and break bread, and we're going to get through this. Now we got him having lawyers write essays. Now at a certain point, is it about you, judge? Now you got two different lawyers, and you're having them both do different things. And all right, you're the judge. I could be in your courtroom one day. And if I'm in your courtroom one day, Pro Hoc Vice, I'm not attacking. I'm raising questions because this is not typical.
28, yes, at noon. Or you do 20 days. A 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility.
A 17-page paper. A 17-page paper about treating one's opponents with civility. If it was that bad, maybe you should have held him in 17-page paper. Like, what is that about? There's more to the story. Maybe the judge is actually doing this lawyer a favor, but you combine that with the take your adversaries to lunch. Woo! What's going on in this courtroom?
Papers to be published quality in APA format and at least 10 primary and 10 secondary sources.
At least 10 primary and 10 secondary sources. I'm gonna make you take 3 days of your very busy life where you're out representing people to go show me that you will basically bow down and write this essay. Maybe he did something so absurd that the judge is being nice. Maybe. Or maybe the judge says, like, I have the power, what are you gonna do about it?
How about the Theodore Edgecombe case? This was the man on trial for first-degree intentional homicide out in Milwaukee County, Wisconsin, for shooting to death Jason Clearman. It was a road rage incident gone bad, with Edgecombe claiming that Clearman called him the N-word and to get the F out of the road after he says their car clipped him while he was on his bicycle. An altercation ensued after Clearman got out of the car. Edgecombe shot him. It was a case of, was this homicide? Was it self-defense? Well, there were a few times during the course of this case when Judge David Borowski got into these heated back-and-forth moments with Edgecombe's counsel. For example, here's what happened when the defense wanted to call a certain witness testifying about what would constitute a threat.
Mr. Brums has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat. Your Honor, I would like the defense to name me one case where Detective Burns has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one. So hang on. So would I. Well, a case number that occurred in Milwaukee County. Well, the state hasn't asked for any type of addendum to Mr. Brums. I'm asking. I'm asking. Well, Mr. Brums is not here right now, but hang on, counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County.
No, that's not fair. First of all, in Milwaukee County, there's a bunch of judges. So I don't know who's right. I have no idea if this witness that they want to call has talked about the thing that he just represented to the court. What he's basically saying is, prosecution saying this witness should not be allowed to testify to this issue. And the judge being like was leaning that way from the argument of defense counsel. Defense counsel, whoa. We want to use this witness for us the same way the prosecution uses this witness against us in other cases. And the judge at the moment is going, well, unless he's done it in front of me, or you can give me the case number where he's done this somewhere else. Well, you know who might maybe know the case number? The prosecutor, if they've used him. Now, maybe they haven't for that. You know who else he could ask? The witness. Now, the judge said, you just represented to this court what this man has done. You are going to bring me case numbers where he has done that. Okay, fair game. But the idea that you need that case number right now, this witness could have done it 100 times. He's not going to know the case number where he's done it. He won't even know specifically many of the cases without talking to the witness who's testified. I get it. This judge is frustrated. Maybe the judge thinks he's being misled, but I don't think that's a fair request of any lawyer.
You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on. Mr. Burns can testify to the cases that he testified in. Name the case now. We don't have those that information. And he's not testifying. I mean, he's testified in several cases. The counsel. He's done it with other judges. Argument does not work with me.
But that's not true, because when you're trying to get someone in many cases to say qualify as a witness, I've never heard a trial judge go, well, I have not qualified this person as a witness in my courtroom, because how limiting is that? Well, I mean, very often when you're trying to get a witness to be able to testify as a witness, one of the questions you ask is, have you ever testified and been allowed to testify as a witness on this issue before? Yes. How many times? How many jurisdictions? And that carries weight. The fact that that judge has an opinion. Now, ultimately, that's not the yes or no by itself, but the idea that, hey, if it's not in front of me, I don't care. Come on. You, judge, we're dealing in a system where you're supposed to follow the same rules as the judge down the hall. So I get it. Like, there's more going on here. You can feel the judge is mad about a lot more than just this argument. At least it feels that way. And so I get it, but I disagree completely that if I haven't heard it in this courtroom in front of me, I don't want to hear it. If this witness has testified in certain ways and been allowed to testify in other courtrooms, that's something I should at least consider. Now, what the judges do down the hall is not binding on me. What appellate courts say is binding on me. This is a trial court judge. He doesn't have to do what other judges have done. But the idea that it's not even persuasive unless it happened in front of him, I disagree.
And then there was the time when defense counsel was questioning a member of law enforcement about whether anything was moved from the crime scene that would maybe tell a different story of what went down. This happened during the actual trial.
You don't know if another item had been moved from one place and put in another place.
Objection, Your Honor. There is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, counsel, that there is no evidence of it.
So I disagree again with this judge. The jury is watching. The judge just gave his opinion in front of the jury about the facts. The proper objection is not objection, Your Honor. There's no evidence that anything was moved. That is counsel objecting, making an argument for the jury. The right objection is objection assumes facts, not an evidence. And assuming it does, the correct ruling is sustained. The jury is to disregard the question or anything in the question suggesting evidence that the court has not heard. But that's not what just happened. There was a speaking objection to basically argue to the jury by the prosecution. And then the judge then stated in words, that's right, there is no, now there may be no such evidence. And maybe this lawyer should be held accountable for saying something that there's not a basis, because lawyers can't just make stuff up, believe it or not. We are required as officers of the court to stick within the evidence. You can't just go making things up that you don't have a good faith basis to believe have or will come in later. That's all true. But at this moment with the jury there, as frustrated as this judge may be, I think he got that wrong.
That is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question.
The other thing is, he's showing his frustration with the jury watching. You may be as mad as you want at this lawyer, but the person he's representing probably doesn't think it's great if the jury sees you hate his lawyer, because that reflects on him. Now, you can't help it. Your lawyer does reflect upon you, good or bad. But I do think judges, as hard as it is, have to try to maintain an appearance of not being biased one way or another. You want to call the lawyer up and say, if you do that again, here's what's going to happen. Do it. You're the judge. Your courtroom. You control it. In front of the jury, you have to be much more careful, and I think that was a mistake.
So the InfoWars founder and host was in a very tough legal situation. He was sued by the families of those who lost loved ones in the Sandy Hook Elementary School shooting, as well as a former FBI agent, for comments that he made regarding the massacre, namely that it was staged, that it was fake, that it was a hoax, that the parents were crisis actors. They sued him under various legal theories such as defamation and intentional infliction.
And then the man failed with a long list of failures in there. If you ever get sued, do not ignore the lawsuit because you think you're right. That's not how it works. I think I'm right. I'm not going to respond. Then you're going to lose. You're giving up your defense if you get sued and you don't do anything about it in the court. So if you think you're right, respond. If you think you're in the wrong, still respond. Don't give up the ability and a platform to even lessen, or it could be an unfair punishment that you get, whether criminal or civil.
And Alex Jones actually automatically lost these lawsuits because he failed to abide by court-ordered discovery obligations. It's called a default judgment. I want to talk about the Connecticut trial, where Norm Pattis represented Alex Jones. Very animated lawyer. And you know, he seemed to constantly interrupt the judge, Barbara Bellis, and she was none too happy.
And so what one does isn't what we're here to show. We're here to show what he did.
Right, but
And
that's
the purpose
different.
is being
No,
offered to
Attorney
get into the
Pattis,
state
Attorney
line.
Pattis, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now, but if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely, I'm literally almost begging you. I have no recourse but to do that. I'll start with Attorney Patty. What do I need to do?
to stop the comments and the call. Just tell me what I need to do. Do I need to hold one of you in contempt? Attorney Pattis? I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it. I'm
Do you
not going to have
expect me
anybody.
to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen.
Hey, I give that judge credit. So that's how you get credibility. 2 decades, I've never held anyone in contempt. I've never sanctioned an attorney. Okay, so if you do it now, it's probably not like you've made 4 people write essays in one trial and maybe you don't have as much credibility. This is a judge who's been a judge for 20 years and has never fined a lawyer. So if she does it, you probably deserved it, right? And you could see she remained calm and respectful even if she felt they weren't. Put on the black robe, but didn't forget she's just a person. Give her a lot of credit. And I'll tell you, I don't know what ended up happening, but if she did hold somebody in contempt, if she did find a lawyer there, who's going to question it? In fact, you ought to question the other way and go, how bad were you? That in 20 years of lawyers showing up in this judge's court, this judge has never had to sanction anyone but until you. You know, that says a lot. Some credit to the Law and Crime Sidebar. Did a really good job. I really liked what they put together and how they discussed it. That was fun. Interesting way to kind of see in the courtroom and get those clips. So if you would like to hear me talk more about what actually happens in a courtroom, a lot of times that what's covered by the media and even online is people who haven't stood in the well and actually been there and had these issues come up. You want to hear more? Let me know what you like. Make sure you comment, follow, subscribe, like, do whatever you got to do. Let us know what you need. And YouTube thinks you're going to love this video right here.
That's for your benefit, not for mine.
Your Honor, I don't think you telling the jury I'm not prepared was for my benefit, but thank you.
How are we doing on that paper? Yours is due by the 28th of April.
I mean, where have we reached when the judge is giving out homework assignments to lawyers?
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
And when you say you're an adult, what number in years are you?
I plead the fifth.
Can we get you to step outside to your headquarters?
This is the best start to a witness that I've seen in a long time, and I cannot wait to see what happens to Lil Woody from here on in.